So I am absolutely thrilled to welcome you all back for the second episode of the Spring 2022 series of UCD What It Takes. This is our second of our pre-conference events leading up to the 7th annual UCD Women in Leadership Conference, which is taking place in person, woohoo, in O'Reilly Hall next Tuesday, the 22nd of March. And it'll continue online on the 23rd of March with online mentor circles. If you do come to the conference, you'll be inspired by trailblazers and leaders in all industries. You get practical tips to support your career and grow your network at all of the networking opportunities throughout the day. As far as I know, my colleague Niamh is dropping a link in there in the chat to the conference if you want to check out the lineup and look at the tickets and things like that. So back to today. Today you'll be hearing from two stellar UCD alumni who will help you to get a handle on what it takes to know your rights. And firstly, we'll hear from Síobhra Rush, Managing Partner at Lewis Silkin, Ireland's Dublin office, in their Employment, Immigration and Reward Division. Following Síobhra's presentation, we'll have a recorded address from accredited solicitor and mediator Richard Grogan, who you also might recognise from his recent rise to TikTok fame. Unfortunately, as I said, Richard is unable to join us live today, but he has very kindly recorded a session which will be really useful. The power of technology. After our presentations today, we'll have about 15 minutes for audience questions led by my colleague Michelle Cohen, who's a careers consultant with the UCD Careers Network. Hi, Michelle. So be sure to drop any questions you have into the Q&A button at the bottom of your screen, and our speakers will answer as many of them as they can at the end of the session. And finally, this session is being recorded, so if you want to revisit it, or if you have trouble with connectivity today, or if you wanted to share it, you can find it on our UCD Alumni YouTube channel starting from tomorrow. It also goes without saying that the information you hear today will be helpful, of course, but it does not constitute legal advice. In case you need it, there are loads of resources online. For example, citizens information, workplace relations, free legal aid centres. We'll share the links in the chat for your reference. Thank you, Niamh. I think she's sharing them there at the moment. And so without any further ado, I'm going to hand you over to Síobhra now, and I will talk to you all later.
Thanks very much, Jenny, and thanks to the Alumni Network for inviting me to present today. I'm delighted to be here. I see you have our slides up. Thank you very much. So yes, I'm an employment lawyer. I've been an employment lawyer for over 21 years, which is staggering because it feels like last year that I left UCD. 2020 and 2021 were obviously very extremely active years in employment law, in particular with COVID and remote working and sick pay and all these fantastic topics. But I think it demonstrated that it is an area that is constantly changing, and it's important for both employers and employees to keep up. I'll probably be focusing on more strategic kind of high level issues that would affect employers, and might focus a little bit more on the corporate world. And then Richard's piece will be zoning in on kind of working time, leave issues, more employee related issues, but hopefully you'll find it interesting. In my view, I think that the biggest challenge for employers at the moment isn't just to comply with the law, which I'll be taking you through, but it is to make sure that employees get a good experience in their work, excuse me, and so that they can retain good talent and attract good talent. So it's not just about compliance now, it's also about making sure that people have a good experience in their working life. So Ria, if we can move to the next slide, I'll just take you through what I'm going to be talking about. And there are issues that I think are going to come up in 2022, well, that I know will come up in 2022 in Ireland around remote work, consultation on flexible work. I'll talk a little bit about gender pay gap reporting. I'm hoping that there will be changes there which are coming very soon, and then also some changes that are coming up in the area of whistleblowing, which is also very interesting as well. So Ria, if we can move to the next slide, which is all about the right to request remote work. Some of you may remember Leo Varadkar launching a consultation, public consultation, where the Department of Enterprise was liaising with both employer and employee representative groups and considering best practice internationally. And this all happened quite quickly because of people being forced into a remote working environment as a result of COVID. And I think it was fantastic because I know that in the older industries in Ireland, they would have been quite traditional in terms of ways of working. Obviously, we have a lot of multinational tech companies, a lot of startups. They're very exciting environments to be in. But I think that some of the older workplaces might not have been embracing remote work until they were forced to. So what Leo announced in January was a draft scheme of a bill. So it's not law yet. It's not even draft law yet, but it is kind of what the law might look like. Some of it was well received and some of it was not so well received. But it will undergo scrutiny by an Oireachtas committee before the bill is finalised. I think it was hoped that the bill would be finalised by Easter and that the right to request remote work then would be law by the summertime. I think that with obviously global developments, there may be a slowdown on that. But just some information about the draft scheme and kind of what's envisaged. What can we expect? So employees who have 6 months of service with an employer should be able to make a request for remote working. Now, I think that because of the fact that we have this kind of gap where the public health guidelines have now taken away all of our restrictions and people are being called back to work, that a lot of employers are actually getting ahead of the game and they are putting in place remote working policies. But in terms of the process to request remote working, it's definitely advisable that employers should put a policy in place, and probably better to get ahead now and amend it if needs be, if the law transpires to be very different. But what's proposed is that an employer should deal with a request within 12 weeks. So there's a bit of an opportunity to consider and reflect on their business needs before they make a decision. So for instance, if there are health and safety or IT considerations that they need to think about. The policy will need to include a timeline, and it will be for up to 12 weeks. Interestingly, employees will have obligations when they make these requests. So they will have to look at the information that they provide to an employer when they make these requests, and that will include the location of work, so where they are proposing to carry out the work, the proposed start date for the remote working arrangement, the number and timing of work days that they will work remotely, and then a self-assessment of the suitability of the proposed remote work location. So that will include considerations like data protection and confidentiality. If they're going to be working in a hub, will they be in a private space? So for instance, in my line of work, in employment law, where we're discussing employee grievances with our clients, etc., we need to make sure that we're in a place that's very confidential, other offices can't hear what we're doing, etc. Minimum levels of internet connectivity and the ergonomic suitability of the proposed workspace. So that's really an opportunity, I think, for employees to put their best foot forward and set out the best case scenario for an employer to facilitate a request. But requests can be refused, and the draft scheme of the bill sets out what has been, I think, named as the 13 opt-outs. And it's not an exhaustive list. It's basically a list of business considerations that employers might rely on to refuse a request to work remotely. And that could include the nature of the work, not facilitating remote work. So for instance, people who work in hospitals or hospitality or bus drivers, where they need to be present and have had to be present during the pandemic, obviously, as well. They're all pretty much on the front line. That's not going to be possible to do that remotely. If they can't reorganize work among existing staff, if they think that it would have a negative impact on the quality of the business or the service. So there's lots of this, as I said, there's 13 different reasons there: data protection grounds, the remote working location not being suitable, if it conflicts with an applicable collective agreement, or if there are structural changes coming down the line in the business. These are all potential reasons why an employer might refuse a request. But as I've said, that list isn't exhaustive. There may be other reasons, and provided they're objective reasons and they're not discriminatory, they don't only apply to the person who's asking, then an employer may be able to rely on it. The draft scheme does give some helpful practical details and examples on the refusal reasons. But if a request is approved, so if the employer says, yes, I'll accede your request, or maybe I'll accede your request, but not the entire one, I'd like just to come to an amended arrangement, well, then the scheme of the bill provides that there must be confirmation in writing, and that must include the exact details of the arrangement, when the arrangement will start, if it's subject to a trial period, so it is envisaged that there will be a trial period permitted, and if so, what's the end date of that? And then to state, is it for an indefinite duration, or will there be a review every 6 months? So making sure that everybody's very clear on what the expectations are around entering into this kind of more formal arrangement that we haven't been forced into as a result of public health guidance. Now, the big contention about this scheme is what claims and complaints can be made by employees if they're not happy. There has to be an internal appeal if the employer says no and they want to appeal that internally. If that doesn't work out, they can then go to the Workplace Relations Commission, the WRC. So that's where all statutory employment claims go to be adjudicated on. However, the scheme of the bill only provides that they can bring a claim if a request is ignored or if it's not dealt with within the appropriate timeframe, etc. At the moment, there's no way for an employee to be able to bring a claim if they disagree with the employer's decision. So if an employer says no and they say the work doesn't facilitate it and the employee disagrees with that, they can't go to the WRC for an adjudication on it. And this is a very tricky situation because, you know, obviously it feels it feels as if it's not very fair if you disagree with your employer's decision. But also from the employer's perspective, they might feel like it's not for an adjudication officer in the WRC to determine whether remote work can be facilitated by them in the context of their business, which they obviously know much better. So it's a tricky situation, and it'll be interesting to see whether the actual law, when it comes out, changes around that. However, if an employee does bring a claim, even based on the fact that the request has been ignored, they can be awarded up to 4 weeks remuneration. And there's also a potential criminal conviction if an employer doesn't put a remote working policy in place, and that's up to €2,500 for a fine. So for now, employers should definitely work with various stakeholders in their organisations to develop their policy. So speak to their health and safety, look at their IT requirements. They should look at putting a policy and procedure in place for remote working arrangements, put in place remote working agreements as and when they are to be entered into. I put remote working abroad in there because I know that some people have been facilitated in this during the pandemic. It also is a very tricky situation because if, for instance, somebody starts working in Ireland here, they do accrue employment law rights from day one, from when they start working here. And I think that that could happen if they go and work elsewhere. So it's not as easy as I'll bring my laptop to Portugal and work from there for a month. There could be social welfare considerations, there could be data protection considerations, confidentiality, tax, regulatory. So for instance, if somebody is working in a role that's regulated by the central bank might not be happy with the idea that they would be performing their work in a completely different jurisdiction. So it's unlikely that the right to request remote work will operate on requests for remote working abroad. So again, a space to be watched, and hopefully we'll have an update on that in the summertime. If I could go to the next slide, Ria, please, which is on flexible work. And you'll note that there was a consultation on flexible work in 2020. And this was undertaken by the Minister for Children, Equality, Disability, Integration and Youth. So it's quite interesting for us. We have to keep an eye on two kind of departments. It's not just the Department of Employment, Enterprise and Innovation. We also have to keep an eye on the equality element of work and flexible work and parental leave, parents' leave, carers' leave, etc. And that all comes from a different department. So that's why the consultation was through there, even though it's work related. So just to put a context on where the right to request flexible work might come from, there's a work-life balance directive, which has come down from the EU in 2019, and that must be implemented by Ireland by 2022. And it aims to make it easier for people who work in the EU to balance their paid work and private life, and that includes caring responsibilities. So it introduces minimum standards for parental leave, including paternity leave, carers leave, the right to flexible working arrangements for parents and carers, and then safeguards against unfair dismissal. Now, bear in mind that this directive operates across all countries in the EU, some of whom have better rights in those areas than others. I would argue that we had some very good, there's a lot of those things that we have implemented already. We have a Carers Leave Act since 2006. We have a right to request flexible work for employees who are returning from parental leave. We already have paternity leave. But in any event, it may be that there will be a right to request a flexible work arrangement, and that should be differentiated between the right to work remotely. So working remotely could be working in a hub, or it could be working in your home. It's somewhere where your employer's principal place of business is not. Flexible work is very different. That refers to work patterns. So it could be flexi time, if there's a compressed working week, if somebody opts to do a 5-day working week in 4 days, if they do 4 10-hour days rather than 5 8-hour days, they might have different start or finish times. They might have term time working. The UK is quite interesting in this area. They have they already have a right to request flexible work. It operates in much the same way as the right to request remote working. But again, something positive for employees in terms of getting more rights to make requests around flexible and remote work that could be coming down the line this year again. If we could have the next slide, please, Ria. This is probably one of the more immediate things that we're going to see this year around gender pay gap. Now, some of you may know that we do have a Gender Pay Gap Information Act, which was signed into law in 2021. However, it hasn't been yet commenced. So we're waiting for regulations that will both commence the obligations on employers to report on their gender pay gap, but will implement the law. So at the moment, the act is kind of sitting there, and it will also give us better detail around how employers are supposed to do this. So many of you will know, if you keep an eye on this area, that there's a concept known as Equal Pay Day, and it's the day in October or November, I think, after which women are effectively known to be working for free for the rest of the year because of the gender pay gap. Now in Ireland, that is currently 14.4%. It's really important that people realise that the gender pay gap isn't the same as equal pay. So for instance, if I was working on a factory line and I was doing work and there was a male person who was doing the exact same work as me but getting paid more, that's equal pay, and that's the right to equal pay for equal work, and that's discrimination on the ground of gender. Whereas the gender pay gap is the difference between the average hourly wage of all men and women across the entire workforce. So you're really looking at kind of an umbrella type arrangement or focus, as opposed to an individual female's pay versus an individual male's pay. And obviously all workforces will have a gender pay gap because there are a lot of reasons why organizations have them. When you think about it, in the 1970s, so not that long ago, at least for me, women in the civil service had to give up work when they got married. So we just haven't seen enough females working their way up into management in lots of workplaces. But this is a really good initiative in terms of showing employers that they have to look at this and they have to take steps to try and narrow that gap a little bit. So for instance, the fact that a greater proportion of women take on caring responsibilities, and we'll have seen during COVID that that was very much the case. And in fact, a lot of women may have stepped back from the workplace as a result of their caring responsibilities. There are more women in flexible working arrangements. Men tend to occupy the higher paid roles in many organizations, and again, that's for social and economic reasons. And then some of the higher paid sectors, for instance, in financial services, tend to be male dominated. So the mandatory reporting obligations will apply to private and public sector employers, and initially it'll be to employers with over 250 employees, but that will come down. So in year 2, it will apply to employers with more than 150, and in year 3, over 50 employees. And what they'll be required to publish is the gap, so the difference between the mean, so the average pay, and the median. So if you take all of your employees and you pick the person in the middle, so you pick the person in the middle of the males and you pick the person in the middle of the females, and you have to then publish the gap between their remuneration. So you have to publish the difference in their overall remuneration, but also you have to work out the hourly rate and report on that, and you have to report on bonus, and there's other factors that employers will have to report on. But in addition, we've gone slightly further than the UK in that employers will also be required to publish the reasons for the differences in their pay and the measures that they have either already taken or that they propose to take to either eliminate or reduce these differences, which is a great thing because I think it forces employers to think about, okay, we don't have enough women in management, or we need to recruit and retain more women into the workplace to try and reduce our gap. Now, there's no particular penalty for employers if there is a gender pay gap, and again, as I've said, for social and historical and economic reasons, it would be very suspicious if employers didn't have one. But I would also say employers aren't under any legal obligation to address the deficiencies that have been found but there is reputational damage, and obviously where they've had to publish a report showing what their gender pay gap is, it would be, it's not a box ticking exercise. They would want to be seen to be taking steps to try and eliminate the gap. If they failed to comply with the requirement to publish that information, an employee can bring a claim to the WRC, but they won't be awarded financial compensation. It will simply be a case that if there is a case to answer, an adjudication officer may order them to do the report. Equally, the Irish Human Rights and Equality Commission might also apply to the Circuit Court or the High Court for an order compelling the employer to comply with it. So even though we don't yet know where the or how the regulations are going to work, or how the employers are expected to report, you may have seen the Minister did make an announcement, Roderick O'Gorman, that the snapshot date, so the date on which employers will have to take the pay information, will be June 2022, and the reports will have to come in December 2022. So in the meantime, employers could take some steps by, making sure, are there entities in Ireland that need to report, look at the headcount of those entities, look at the key stakeholders that they will need to work with in compiling their report, so HR analysts, payroll, IT, do they have the necessary technology and resources available? I think I've put a question there saying, does gender pay gap reporting help? And I think overall it does. As I've said, it requires employers, you'll see a lot of employers talking about their diversity and equality agendas. And, it's a great opportunity for them to reflect on their company values and their policies to address any forms of inequality, whether that is gender or otherwise, as part of their diversity and inclusion agenda. So I don't think it's going to cure the equal pay problem very quickly, but I think that it will certainly help to bring the issue up the diversity agenda. So my last slide is on whistleblowing. And actually, Ireland is a bit of a leader in the EU in terms of our whistleblowing law. We already have existing legislation here, the Protected Disclosure Act of 14. So really all that's going to happen this year is that the Whistleblowing Act will be amended to comply with another EU directive. Now, we are late in implementing this. It was supposed to be the 17th of December 2021, but obviously with COVID and now with our global issue, I would imagine that we will be forgiven any delay on it. Basically, the definition of a whistleblower will be broadened, so it won't just be protection given to employees. It will also apply to volunteers, unpaid trainees, board members, shareholders, and job applicants. And basically, just to outline to you what protection this gives, it's for workers who've made what's called a protected disclosure. So it's relevant information in relation to wrongdoing. And if they are dismissed or if they are demoted as a result of having done that, well, then they can bring a claim. And a wrongdoing is the commission of a criminal offence, failure to comply with legal obligation, health and safety issues, damaging the environment, etc. I think that our law falls short in one major respect, that it doesn't require there to be a public interest requirement. So we have one case that just came down from the Supreme Court very recently, whereby an employee who had injured themselves and raised this as a health and safety issue, that was deemed to be a protected disclosure. Even though it affected him, it did potentially affect the wider workforce. So I would welcome a change on the law there, but I'm not sure if it will come. Also, there will be more strict requirements on employers, as if they get a disclosure, they have to respond and acknowledge receipt of that within 7 days, and then they'll have to provide feedback on that within 3 months. And that might seem like quite a long time, but actually on some complaints, and particularly for global companies, it can take a very long time to investigate those kind of things. So that is definitely a more stringent requirement. And then the penalisation. This is interesting. Penalisation at the moment would be like dismissal, demotion, whereas the proposal is to widen that, so that if somebody gets a negative performance assessment or training is withheld, that could be penalisation as well. So I think it's going to be quite tricky for employers going forward. Now, obviously, an employee will have to show that they've made a protected disclosure, but there will be changes in the burden of proof as well. So that's going to be an interesting area to watch. So hopefully that gives you all a good flavour of what's coming down the line in 2022. That's going to be keeping me busy. I'm going to hand you back to Jenny now, who's going to show Richard's piece, and then I'll be available for questions after that.
Thank you so much, Síobhra. That was absolutely fascinating. I thought the information around the applying for remote working is obviously particularly timely for a lot of people at the moment. And then the piece on the gender pay gap is particularly relevant ahead of the Women in Leadership Conference. We have Dave McRedmond in an interview at that from On Post, who had recently announced a 0% gender pay gap there. Interesting just to hear your thoughts on that. So anyway, it'd be absolutely fascinating. Thank you for that. So now we will hear from Richard Grogan, accredited solicitor and mediator and prolific TikToker. As I mentioned earlier, unfortunately, Richard is unable to join us live today, but he has recorded a session, and the information he has to share will be really useful, especially for students and people with part-time jobs who have joined us here today. So without further ado, I think Ria is going to start sharing that, and I will bow out.
No, I'm sorry I can't be there today. So unfortunately, you're getting a recording of me today. So we'll deal with some of the issues that are coming up, and there are issues that I suppose are affecting students quite an awful lot, and the ones that you may need to be thinking about. So those of you who go off getting, a part-time job, or you get a job while you're in college, and you get a contract, and you'll have a probation period in it. So what are your rights there? Well, generally speaking, until you have the full 12 months working, you don't have any rights for unfair dismissal. Now, there are exceptions to that. For example, the recent Ivy case, so if you're involved in trade union activities, for example, that's going to give you protections, and there's a number of protections there. I suppose the ones that we would come across in practice most of the time is somebody is dismissed because they're pregnant or something like that, or there's but generally speaking, the probation period can be up to 12 months. Now, that is actually going to change in August of this year, and there's a new directive coming through, which is going to limit probation periods to 6 months. And you'd say, well, that's great. I'm glad to hear that now. So that means after 6 months, I'll be full-time and I'll be protected. All right. There's a little bit of a problem there, because unless they change the unfair dismissal legislation, you can be as permanent as you like, but unless you have the 12 months, you won't have an unfair dismissal case. So it's going to be interesting to see, in enacting the directive, which has to come in by August of this year, will the government, by the middle of July, because that's when they go on holidays, remember, they have even longer holidays than students have, they're going to have to change that piece of legislation. Now, if they don't, and if they don't bring in the directive, because they're very good at not bringing in directives in time, you have the problem that there will be direct effect, because there's a recent case, well, it's a couple of years old now, but it was Ronald Boyle and others in the Workplace Relations Commission and Garda Síochána. And as a result of that, the European Court of Justice said the directives have direct effect against private employers. Before that, it was only against the state. Now they say it's against everybody. So you'll have a situation where you can say, well, I'm permanent, and the employer says, yeah, well, you haven't got 12 months, so you're still fired, and you don't have an unfair dismissal case. So what's going to happen on that? I've absolutely no idea, because to be quite honest with you, I would say that there is very few in the Department of Enterprise, Trade and Employment who've ever even looked at the directive, not talk about then looking at the unfair dismissal legislation. So it would be a major change in Irish law if they brought that down to 6 months. So that's going to be a big issue for those of you who are there working away. So what's your protections? Generally speaking, if you've got a part-time job, the answer is you probably have no protections at all. Now, the other one is you go and get the job, and you get a job, and they say, we're going to give you a bit of training. Sure, isn't that great? Fantastic. They're going to train me, to stack shelves, or to put pints on tables, or to bring out food and put it on the table. And you find out that you have to do 2 shifts for the training, and the training is go into the kitchen, collect the stuff. And they say, well, we don't pay for that training. Right. Well, that's a breach of the national minimum wage legislation. And it's the oldest trick in the book, used particularly by takeaways, pubs, and some unscrupulous restaurants are the ones who do it. And it's training on like how to use the cash machine. You know, take out card, put it up against machine, right? See that it goes approved. You know, how to put in the figure of €17.27. It's 1727. Yeah, that's rocket science now. You'd need to be sort of like at least 3 years doing a maths degree in Trinity to be able to work out how to use the cash machine. So, training. If the only training that the Labour Court recognises as proper training is one that's going to give you a certificate at the end. So it is a recognised training programme. So if I put it this way, you're in UCD. The courses in UCD have to be approved. It's not just they decide that they're going to, we'll teach an archaeology course and we'll give fellas a spade and say, dig a hole. And when you get down to the bottom of it, whatever you found, it has to be properly set out. So the same thing in training. So if they're giving you training in a restaurant or somewhere like that on, we say health and safety or fire safety or any of those things, unless it's a recognized training course, which is going to be done by a recognized trainer, and it's going to have a questionnaire and all the rest, that's not a training course. But even that kind of training is training that you have to be paid for, and you must be paid the minimum of the National Minimum Wage Act. So you could get a job, for example, where they say, we're going to pay you €14 an hour, but we need to train you on how to put, how to lay a table correctly or something like that. And that's going to take a shift, and we're only going to pay you $10.50 for that. Well, that's allowed because that's the training that's there. It's slightly different, but you can't have free training. People like free training. So just to let you know about that. So I was asked then to talk about the right to disconnect, but I'm going to deal with another issue first that comes up quite a lot. And this course has been given on the 16th. So the following day is Paddy's Day, and the 18th is our great COVID extra day. And a lot of you will have part-time jobs, and some of the stuff that I'm hearing now is quite interesting. I heard that the 18th doesn't apply as a day off for part-time staff. Rubbish. It absolutely does. So what is your rights to get paid for the public holidays? So it's fairly straightforward. It is, have you worked 40 hours in the last 5 weeks? So if you've worked 40 hours in the last 5 weeks, then you're entitled to the 2 public holidays. Now, what's going to come up on that? Well, we'll take the easy one. I normally work on a Thursday and Friday, or one of those days anyway. Well then, normally, unless the employer has told you what it's going to be, you're normally going to get an extra day's pay. Now, that's not double time. I keep telling people, oh, it's double time. It's not. So let's say you normally work a day on your shifts. You normally work 4 hours shift, right? And on Paddy's Day or the 18th, they want you to come in and work a 6-hour shift. So you'll get paid for your 6 hours, plus you get an extra day's pay, which is 4 hours. So it's not double time. Now, what happens if they say we only need you in for an hour because we need somebody to take the milk in and the papers and stack them up? Just come in for an hour on the 2 days and just help us get set up. Well, then you get paid for the hour, plus you get the 4 hours being the normal. So the first thing is, don't let anybody tell you that the 17th and 18th doesn't apply to part-time workers. Right. Now, the next one that you have is what happens if you don't work those days? Then generally speaking, it's a fifth, i.e. it's a fifth of a normal week's wages. All right, so you get paid something if you've done the 40 hours in the last 5 weeks. Now, the other one that comes up is holidays. Everybody loves holidays. I like holidays. And what are your rights there? Now, your rights to holidays there depends on how many hours you work. So if you work over 20, if you work 27 hours a week, and some of you will, then provided you do 1,360 hours in the year, you're entitled to 4 weeks holidays, paid. And that's paid. And how do you calculate the holiday pay? It's the average of the 13 weeks before you go on holidays. Now, if you've got a part-time job and you started in September and you're finishing up in June, you probably won't have the 1,360 hours. In that case, you're probably going to go on the 8% rule. So it's 8% of what you've earned, and you're entitled to that. Now, you're not entitled to be paid instead of going on holidays unless the job is finishing. So if they're finishing the job, you can get paid instead of getting anything else. But if you're going to continue the job, like you sort of say, well, I'm available to work over the summer and can start on that great. And you'll be able next September I'll be back here. Yeah, fine. Yeah, well, now you're going to have to get paid holidays. You can't go, could I have the cash, please? Now, I know students will all like cash, you know, if you want to get a bag of cans, you need cash rather than going off on holidays, right? So you can't get the cash in lieu. So I've covered that one off. So just so that you've had it. And the other one then is the right to disconnect. Now, this is a big one that comes up in workplaces more, but let's take the type of jobs that you're going to have. So if you're working 4.5 hours, you have to get a 15-minute break. If you're working 6 hours, then you have to get the 15-minute break. So you work 4.5 hours plus another 15, which is 4 3/4 hours, and you do another hour and a half, and then you have to get a 30-minute break. So they're your basic rights. So if an employer is smart, what they do is after 4.5 hours, they give you the 30-minute break. And the 30-minute break after 4.5 hours covers the break after 6 hours. So you get the 4.5 hours, you get a half an hour break. So you'll be there 5 hours. You have to work another 4.5 hours before you get another break. Now, what's a break? Now, a break, you think I'm asking a question, and the stuff that I get in regularly to this office is great. A break is a break, which means you're entitled to go off and do whatever you like. It's your time. So they can't say, well, we'd like you to be sitting in the back of the place here, and in case somebody comes in that you're available to serve them. That's not a break. A break is time for you to use as you wish. Now, they can tell you, well, if you're going to be there on your own mobile phone, texting everybody all over the place and checking TikTok and Instagram and other things, you can do that outside. They're entitled to do that. They don't have to give you a canteen or anything like that, but they have to give you half an hour to go off and do, if it's a half an hour break or a 15-minute break, to do whatever you like. So they're your very basic rights. Now, they're the ones that kind of come up with students regularly. And if you think that they don't, I've got a case coming up fairly soon against a restaurant which broke all of the things that I've mentioned today. So we'll see how that one gets on. So what I want to say to you is, I hope this is of some use to you. I'm sorry I couldn't be there today. I was there recently, but I couldn't be there today. So thank you very much for inviting me, and I hope this is of some help to you. Thanks very much.
Okay, well, we might go on. That was great to hear Richard's presentation, but we have an opportunity for some Q&A. And so if anyone would like to type into the Q&A box at the bottom of the screen, you'll be able to pick up your questions there. But there are some questions coming in already, Síobhra, for you, if you're happy to take some. So I know joining us on the webinar today, obviously we have students, but we also have, people at different stages in their career, some managers, team leaders, company directors, etc. And I suppose just in relation to you were talking about developing a policy, and you mentioned, consulting health and safety and IT, but can you speak maybe a little bit about the importance of wider consultation with maybe hosting focus groups with the employees around the development of an effective policy?
For remote work, is it?
Remote working, yes.
Yeah, I mean, it will really depend on the nature of the workforce as to whether or not there's any type of information consultation body that the employer normally develops policies with. At the moment, it's all contractual, so employers are entitled to develop their own remote work policy. I think it would be remiss not to do any kind of vox pop among the employee population to find out exactly kind of what's wanted, whether it's hybrid scheme, whether it's not. I do think that one expectation, I guess, that has been created is this idea that everybody was able to work from home during COVID, so we should just be able to continue to do it. We've been able to work effectively. And while people might think they've been able to work effectively from home, it could simply be that they've been able to kind of keep the business afloat, and we've been getting along. But I think that as normal, whatever that may be, going forward, our normal working lives will definitely be different, but also employers might want to make plans about growing their business or about running their businesses differently than the way they've been run for the last 2 years. So the fact that somebody has been able to work remotely for the last 2 years doesn't automatically guarantee them acceptance of a request. So yeah, I do think that some consultation would be required, similar to health and safety consultation, that should be there, maybe appoint a lead worker representative. But it is really up to the employers. I mean, there's no major provision in the bill for consultation around development of a policy. But I think that it would be advisable for employers to try to do that, to see how it's going to work in the organisation.
Yeah, perfect. And just in the legislation as well, is there anything around where a request is declined? Can an employee, make a request again after 12 months, or is it declined and that's it?
Yeah, no. There will be an entitlement to do it after 12 months, or if the employee has changed jobs, they might be able to do it earlier.
Okay.
I don't know whether that will go into the final legislation, but that is what's proposed. So, and actually when making the request, they will be obliged to confirm when they last made a request, so that you can't have these serial requesters who just keep getting denied and keep pushing until they get what they want.
Very good. And then we have a question as well from Thomas, and it was around the working abroad. So he just mentioned in relation to remote working from abroad, do you think that the European Commission will take this topic up at some stage in relation to a harmonisation of employee legislation and laws, and maybe facilitating the free movement of workers?
I don't know. These things have so many, there's so many factors coming in. You've got tax, you've got employee rights, you've got residency visa. I mean, not even everybody, work permits as well.
Yeah.
I don't know. I mean, in my experience, a lot of employers, where they are multinational, and if they have an entity in a particular jurisdiction, they might facilitate a remote work from abroad on that basis. But so many things. I mean, what if, for instance, you have somebody who is employed by an Irish company on an Irish salary, and then they move to, somewhere where the cost of living is so much less and they're earning so much more than their colleagues in the Portuguese entity. I think it throws up an awful lot of issues that people may not be aware of. And I think it could just be very complicated for the Commission to deal with. Could I just also come back to Jenny's point around the ONPUS, the gender pay gap, and the fact that So they've, just in case we run out of time, I just wanted to address that. They've been fantastic in doing a gender pay gap report since 2019, when they didn't have to. Obviously, the law still wasn't implemented here. And they've managed to reduce their average gender pay gap from 3.7% down to -2, which is brilliant.
Yeah.
There is one but, which is that their median pay gap, which is the difference between the middle earner in the women and the middle earner in the men, that has actually increased.
Okay.
So they've obviously hired more women in management, and that has drawn the average pay of women up, which is absolutely fantastic. And it may be then that if they've hired more women at the lower paying jobs, then that has pushed the median down. So it will be interesting. They haven't published, how these changes have been achieved or what the reasons are, which they might be obliged to do once the law comes in terms of their gender pay gap reports going forward. But I mean, they've really been a leader in this area. It's been really interesting. I'm sorry I won't be able to make it on Tuesday now.
Yeah, no, I think a lot of people are very much looking forward to hearing about that next Tuesday. Really great. But yeah, it is. I've heard them being interviewed, and they've had some. It's got great publicity so far, so it's very interesting.
Yeah.
But yeah, and that's perfect in relation to the EU question. I mean, there's even tax laws. We haven't got harmonisation of those, so we're a long way off. Maybe the employer piece.
Yeah, and there can be quite a difference between jurisdictions and how we implement directives. So say the Nordic countries could implement things, EU directives, in a very different way that Greece or Spain or Italy might. I even see it with transfer of undertakings, the difference between how local legislation implements even a directive. So I think the remote work abroad will continue to bubble, and will probably just remain a private matter as between employer and employee as to whether it can be facilitated.
Yeah, very good. Well, good question, Thomas, but we might be a bit off yet. We had another question then, just in relation to the whistleblowing. So just one of our participants just asking, can you talk a little bit about maybe what kind of complaints count as whistleblowing? So, for example, health and safety breaches and things like that.
Yeah, so what we have is, we call it irrelevant wrongdoing. It's a disclosure of irrelevant wrongdoing. Now, it has to be in connection with your work. So it has to pertain to the work that you're doing. And it includes commission of a criminal offence, failure to comply with legal obligations, endangering the health and safety of individuals, damaging the environment, miscarriage of justice, oppressive, discriminatory, grossly negligent acts or omissions by a public body, and then concealment or destruction of information. Now, it is still very narrowly defined. So the UK actually had to amend their Whistleblowing Act to put in a qualifier that there had to be a public interest in it, because our Protected Disclosures Act at the moment is very narrowly drafted. And it does mean that, things that affect one employee could arguably be a protected disclosure. So that Supreme Court case that I was talking about, the Baranya and Rostera meets, actually held that an employee who's, they had a sore hand and they reported it to their employer, and they were dismissed 3 days later. And even though the WRC, the Labour Court, the High Court all agreed that it wasn't a protected disclosure, the Supreme Court said actually it is, because it is a health and safety matter. And even though you wouldn't necessarily think of it as being whistleblowing in the context, say, of Maurice McCabe with the Gardaí, where there was a much wider issue, it's still a health and safety issue. There will be an exclusion, hopefully, in the new law that matters between two employees. Like, if you have a barney between two employees, for instance, that would be a private grievance that they won't. So if they're exclusively between two employees, that won't be a protected disclosure. And there is always a fine line between what's an individual grievance versus what's a protected disclosure. I would prefer to see the public interest matter go in there, because I just think it creates too much uncertainty for employers as to, is this a protected disclosure or isn't it? Now, again, the new law will also have a kind of initial assessment. So it will enable employers to have a look at the complaint and determine whether or not they think it's a protected disclosure. But you know, as you can see, some of the adjudicatory bodies might disagree.
Yeah, very good. And then just one other question, just in relation to your rights in relation to having a safe physical workspace or a work environment. And this might be coming up in terms of the shift from working from home and then working maybe in the office as well. And that's probably, again, probably down to an individual organisation and their health and safety policy. Would that be right? So,
yeah, I mean, yeah, if somebody is permitted to work remotely, then that's a place of work, and the employer does have an obligation to make sure that the place of work is without risk, or at least that risk has been minimised, and to provide a safe place and safe equipment to enable an employee to do work. However, if they can't facilitate that, then the employee may need to come into the workplace. So it should be at the cost of the employer. And, you know, I think that's the kind of thing that could put smaller employers under a lot of financial pressure, where, you know, if they want to try and recruit and retain good talent, and that talent wants a hybrid working arrangement, you know, are they going to have to go to additional cost in terms of making sure that somebody has the right chair and that their desk is at the right height to enable them to do that remote work? So yeah, again, a lot of considerations, but health and safety when working remotely, if it's an agreed arrangement between employer and employee, that is a matter for the employer. I would say there's a brilliant remote working checklist on the Department of Enterprise, Trade and Employment website, and also the Health and Safety Authority has really good resources on remote work as well.
Oh, brilliant. That was the next question in relation to good resources. But yeah. You mentioned citizen information, say around the whistleblowing policy. Is there anything else that is a good resource for employers and employees who want to just read a little bit more on the topics you raised today?
Yeah, citizen information would cover a lot of it. I know that there is a Whistleblowers Ireland website, I think, which covers a lot of information around that as well. Now, the law is still in flux, I guess. It will contain information that is based on the Whistleblowing Act 2014. It might not necessarily include the changes that are going to come in. But citizens information and the workplace relations website as well is great for all those kind of statutory rights.
Brilliant. And I can see Neva's sharing all those great links in the chat as well, so they're there for everyone. So I'm conscious of time. We're coming up on the hour, and I want to. Jenny has some details to share as well, probably in relation to Tuesday. So thanks very much, Síobhra, for sharing all your insights. It was so interesting, just to get that snapshot, and lots of resources now for us to follow up. So thank you, and hand back to Jenny.
Thank you so much, Michelle, and thank you. Yeah, thanks, Síobhra. Sorry for talking over you. So just say thanks, obviously, to Richard and to yourself, Síobhra, for those fantastic presentations and that really interesting Q&A session there. There's so much to consider. And thanks also, Síobhra, for your comments on Post. Yeah, there's I thought you might have some thoughts on that, all right? So just on the Careers Network, remember, if you're a student or if you've graduated from UCD in the past 2 years, you can still take advantage of the many events and consultant advice from the UCD Careers Network, where Michelle works. You can also connect with Síobhra and Richard on LinkedIn after this session, and the links to their profiles have been posted in the chat. If you're not already following Richard on TikTok or Instagram, you can find him at Richard Grogan Solicitors. You can also find the slides from today's presentations, as well as numerous other resources in the What It Takes Resource Hub on the UCD Alumni Network at the link that is being dropped in the chat here. And just a few final notes on the upcoming events before we wrap up. As I've mentioned at the top of this, it's been mentioned a bit throughout, the UCD Women in Leadership Conference on March 22nd, which is this coming Tuesday after the 4-day weekend. So it would be great to have everybody back in person for that in O'Reilly Hall and online on the 23rd. So again, the link was posted earlier on in the chat. If you're interested in finding out more, you can find it at that link. You might also be interested in our next What It Takes webinar, What It Takes to Stay Ahead of the Digital Curve, with Fintan Murphy and Ebony Lawless McRae on Wednesday, March 30th at 1 o'clock. You can sign up for this at the link in the chat. And finally, this series aims to support our UCD community with career development opportunities. But I'd also like to mention our commitment to supporting our students through the COVID crisis. Generous funds have been raised thanks to alumni and friends of UCD like you. If you would like to support our efforts to provide urgent financial and mental health support to those students who need it most, you can visit the link that's been dropped in the chat here at the moment. And just to say that is all from us. Thank you so much for being here. Thanks again to Síobhra, Richard and Michelle. Thanks for joining this afternoon, and hopefully we'll see you next week at the conference and or at the next What It Takes webinar on March 30th.